Bom dia a todos, meu nome é Leonardo Nemer Caldeira Brant, eu presido o Centro de Direito Internacional com sede em Belo Horizonte. É com muita alegria que eu saúdo a todos os presentes, saúdo igualmente os professores internacionais e nacionais que irão estar conosco durante essas 2 semanas, durante o 16º Curso de Direito Internacional. Eu gostaria de dizer que, em primeiro lugar, esse curso foi todo desenhado num novo modelo online. Nós já estamos aí no 16º curso desse gênero. Ele foi totalmente adaptado às novas circunstâncias, o que, de certa forma, permitiu também uma extensão do número de participantes, de professores internacionais e nacionais participantes. Temos este ano 19 grandes nomes do direito internacional que estarão presentes conosco durante essas 2 semanas. Num primeiro momento, portanto, eu gostaria de agradecer a todos os professores que colaboraram conosco, que estarão conosco nesse período, com palestras muito interessantes sobre temas dos mais variados do direito internacional. A todos eles, o meu muito obrigado. Em segundo lugar, saúdo e agradeço também aos alunos, aos estudantes que estão participando neste período de julho, conosco durante essas 2 semanas. O nosso também muito obrigado. Esse é um curso que envolve uma grande equipe do Centro de Direito Internacional, a qual eu tenho imenso orgulho de colaborar e de presidir. Ele é um curso que pretende trazer para o Brasil e para a nossa América Latina o mesmo modelo de cursos que, de forma quase centenária, já é uma tradição nos países europeus e nas principais universidades do mundo. Portanto, para nós, uma grande satisfação que tenhamos ele já há mais de uma década no Brasil. O curso de inverno de Direito Internacional, com toda a sua abrangência e extensão, não seria possível de ser realizado igualmente se não fosse a relevante parceria e a confiança e o apoio da Fundação Konrad Adenauer no Brasil. A ela estendo um caloroso agradecimento e tenho a certeza de que estamos contribuindo juntos para os valores do direito internacional, para os valores dos direitos humanos, para os valores do Estado Democrático de Direito, para os valores da democracia e, com certeza, para a compreensão e construção de um mundo, de um universo internacional mais justo e mais equilibrado. Portanto, agradeço de forma calorosa ao apoio da Fundação Konrad Adenauer no Brasil. Gostaria, portanto, de dar início ao 16º Curso de Inverno de Direito Internacional, esperando que todos tenhamos 2 semanas de muitas atividades e aprendizado. Um forte abraço a todos.
Okay, let's begin. Can I begin?
Yes, for me, you can.
Oh, yes, okay, good.
Please.
Good morning, everyone. I'm so sorry, but Professor Lucas can be with you today, and he asked me to be your hoster, Professor Michael. Professor Michael Wood, it was already well presented for you, everyone, and he is a member of the International Law Commission and a senior fellow of the Lauter Park Center for the International Law University of Cambridge. Professor Michael, it is a very pleasure. Sir Michael, Sir Wood, it was a very pleasure for us to hear you the last day. And today I hope to continue talking about the identification of the customary international law. Take your time. You can begin as soon as you want. Thank you very much for your presence here today again.
Well, thank you very much, Professor. I should say I'm not a professor. I'm a practitioner, not a professor.
Oh, yes, I'm so sorry. Yes.
Anyway, firstly, to thank the organizers again, and to thank Professor Brandt in particular, who we just saw, and Paula for all the organization. I plan, as last time, to speak for about 50 minutes, not more, and then leave plenty of time for questions. I think answering questions is much more interesting than just speaking.
Okay.
In the first lecture, I talked about the International Law Commission in general, and gave a brief overview of the work it has done in the field of the sources of international law. And now in this lecture, I want to focus on customary international law. There are really two aspects to this. The first is how the International Law Commission itself approaches questions of customary international law in the course of its day-to-day work. That's quite a difficult subject, but fortunately the UN Secretariat, the Codification Division, prepared an excellent paper back in 2013, which I would commend to everyone. It's a memorandum on elements of the previous work of the International Law Commission that might be relevant to the topic identification of customary international law. And the members of the Secretariat went through, I think, all the work of the International Law Commission and tried to distill the way it had approached the identification of customary international law. And they came up with no less than 31 observations, which make a lot of sense, and they're actually not so different from the work that the International Law Commission then did when it came to its conclusions. But I won't say any more about how the International Law Commission itself looks at customary international law, other than to commend that memorandum to all of you. The second aspect, of course, is the work of the International Law Commission on the topic identification of customary international law. I'm sure everybody knows that customary international law is often regarded as a great mystery for students and for teachers, though I have to say that in practice, it's not usually so difficult. I think it's made mysterious by quite a lot of the academic writing on the subject. Strange theories are put forward that try to take apart the accepted view of customary international law. It's also, I think, difficult, partly because of this, for national judges and for lawyers who are not experts in international law to approach questions of customary international law. And it was particularly with this in mind that the International Law Commission took up the subject. It was felt, and some of the judges in England, for example, told me they would find it very useful if there was a more or less authoritative guide to how to find rules of customary international law. They said the same about jus cogens. They said even more, they would like to have a guide to jus cogens. But so it was this approach to try and come up with some guidance, not too dogmatic, some flexible guidance, that the International Law Commission approached the topic. And I was appointed the Special Rapporteur in 2012 for the topic, Some 5 or 6 years later, we completed the work in 2018. I'd like to emphasize, though, that it's very much a collective work by the Commission. The Special Rapporteur has an important role. He or she puts forward reports with their own views, their own proposals, but these are almost always radically changed by the debate and the discussion in the Commission itself, and the outcome is not necessarily what the rapporteur proposed. It's almost always, in my view, better. I'm a great believer in the collective approach to these matters. So the outcome from the Commission's work on the topic was really threefold. I call it a triptych, like a painting. Firstly, there are 16 conclusions with commentaries. And these can be found in the in the report of the Commission for 2018. Secondly, there's a bibliography, a very extended bibliography that can also be found in on the website of the International Law Commission. It was updated in 2018, and it's some 30 or 40 pages long. And I must say, I find it very helpful. It was largely prepared by my assistants, and it's really an excellent guide to the literature on the subject. And then the third part of the output was prepared by the Secretariat, and it's a document entitled something like Ways and Means of Making the Evidence of Customary International Law Available. And that is a document of some over 100 pages. The Secretariat contacted every state and a lot of academic institutions to try and get websites to get details of where to look for the practice and opinio juris of states and the practice in particular fields like the ICRC work. And that's a very useful document, a very practical document. Now, the 16 conclusions with commentaries, the first thing to say about them is they have to be read together, the conclusions and the commentaries. The conclusions are usually very brief. The commentaries explain in some detail what the conclusions are referring to, but all together they come to about 35 pages. So it's a very readable output. I compare it always with Professor Pelle's Reservations to Treaties document, which is 650 pages with maybe some 200 guidelines. Here we manage 16 conclusions with commentaries, and they're deliberately kept short, but I think they've got a lot of information in them. Another feature of the commentaries, which is quite interesting, I think, is that they don't contain a single reference to any writings. There's no reference to any academic literature. As I've said, we produced a very full bibliography with the academic literature, but we don't cite it as authority in the conclusions and the commentary. And this was very deliberate. We had quite a long debate about it, with some members of the Commission saying we should, and it's not respectable not to, and others saying that we shouldn't. And very interestingly, they had exactly the same debate when they dealt with the law of treaties under Professor Waldock. And in the end, the final draft articles on the law of treaties from 1966, again, don't contain a single reference to any literature. They refer to practice, to state practice and the like, but not to the literature. And that was deliberate, following a long debate. I think one of the reasons for this is that it's very difficult to be selective. One could, of course, put your favorite book or your favorite article, but to try and be fair, to try and cover the whole world, articles, literature in all the various languages, it's really very difficult. But also, I think it's accurate because it shows the subsidiary nature of literature. So that's the outcome, 3 parts: conclusions with commentaries, bibliography, document on ways and means. The next really important thing is to look at how this was received by states. As I've said, we finished the work in 2018, and there was a debate in the UN General Assembly also in 2018, 2 or 3 months later, in the 6th Committee. And it's important, in my view, to assess the value of a document, to look at the debate in the 6th Committee and what the 6th Committee did with it. On the whole, if you read the debate, I think there's a lot of compliments, states saying that they considered that the conclusions offered important practical guidance on the subject. There was support, very much support, no objection at all to the conclusion, the first central conclusion, following the 2-element approach to customary international law. You have to find state practice, you have to find opinio juris. No questioning of that, unlike in some of the academic literature. There was support for the view that it should be a rigorous and a systematic matter, the search for rules of customary international law, but equally, it was pointed out there has to be some flexibility. And I think the balance between the rigorous nature of the exercise and the flexibility was generally welcomed. There are a lot of elements of flexibility which I could list very quickly. For example, it said that assessing practice, you have to take into account the particular circumstances and the context of the alleged rule. You see this in the jurisdictional immunities of the state case in the ICJ, where they say in this context of the immunity of states, you have to look very much at national court decisions. That is practice of particular value in this field. So there's flexibility there. We also say you have to look at the overall context, the nature of the rule in assessing practice and opinio juris. I should say the fundamental approach we took is that it is the same exercise in all fields of international law. You can't say, well, in the field of human rights, you really don't have to worry too much about practice because all states violate human rights. You just look at opinio juris, what states have said. In the field of international humanitarian law, practice is very difficult to find because it's the battlefield, etc. But the Commission took the position that it is essentially the same exercise in all fields of international law, and that is important to maintain the unity of international law. You can't break it up into separate branches and apply completely different methods to finding the rules in each field. It has to be done by a single method, but at the same time you have to take account of the realities and the context, for example, the importance of national decisions in the case of immunity. Then we took the view that practice itself takes a very wide range of forms, and we emphasize that it includes verbal practice as well as what might be called practice on the ground or practice on the battlefield. What states say is also practice. For example, in a protest note, that can be practice. And that it also includes inaction under certain circumstances, but you have to be very careful about that. We took the view that the same material can be used to find both practice and opinio juris. For example, a diplomatic note protesting about something is practice because the state is protesting about an incident. That's the state's practice. But it also may have opinio juris within it because it will have the state, or it may have the state, saying what its view is of the rules of international law. So the same document, the same event, can be both practice and opinio juris, but it's a separate exercise to look for practice and opinio juris in each case, even if you're looking at the same document. I could go on with the flexibility that I think we built into the conclusions, but I don't think I need to. I would say that one or two writers have commented that it's very inflexible, it's too rigid. There was a blog on opinio juris in the last week or so by Monica Hakimi saying this is completely wrong. They've tried to lay down rules, which actually we didn't. We set out conclusions that are not rules. And they're following a rule book approach. They should be looking at everything and taking it very flexibly. And I think her criticism is not justified. The argument that it shouldn't be too difficult to find a rule of customary international law, of course, there's something in that. But on the other hand, it shouldn't be too easy either. If a court finds a rule of customary international law, a rule that people didn't realize was there before, then they're finding a rule of law that is binding on all states. That's quite a serious thing to be doing. It shouldn't be too easy to find rules of customary international law because they have very important consequences. And if one finds rules of customary international law too easily, it may lead to a devaluation, if you like, of customary international law, with states not taking the system of customary international law seriously. And one of the aims of the Commission is to ensure that the respectability of customary international law, to avoid states saying, well, it's all over the shop, nobody knows what they're talking about. We have tried to show that we do indeed. And those who seek rules of customary international law, seek to identify it, do know what they're talking about and should be following these basic rules. Now, can you hear all right? I saw you putting earphones in. It's all right, is it, the sound? Good. So I think the debate in the Sixth Committee is important. There were a number of comments made, one or two criticisms, which are important and should be taken into account, but not, in my view, fundamental ones. One of the most controversial parts of the conclusions is where it says that the practice and opinio juris of international organizations as such, as opposed to their member states, may be relevant when determining rules of customary international law. That proved to be the most controversial provision in the conclusions, with one or two or three, not many, members of the Commission being rather opposed to that, saying, where is the evidence for this? What does it mean when you have 2,000 international organizations? Can they outvote states? How does this work? And one or two states in the Sixth Committee expressed caution about this. In fact, I think if you look at the conclusions and you look at the commentary, the Commission also have been cautious. They've said it's really only where states have transferred competences to an organization, as for example, the members of the European Union have done to the European Union in quite wide areas of international relations. It's particularly then, perhaps where there's also joint competence, that practice of organizations may be relevant, but also in fields where organizations enter into treaties, for example. That must form part of the practice relevant to the customary international law applicable to treaties involving states. Likewise with the responsibility of international organizations, though I have to say it's often very hard to find the practice of international organizations. On the whole, they're worse than states when it comes to publishing what they do and what they think. So we have also, the Commission has also been cautious, but that was one of the criticisms. There was also caution expressed about the use of inaction as practice. Very understandable caution, but inaction is undoubtedly an important part of the practice that builds up rules of customary international law, but it has to be deliberate inaction. It's not just a state doing nothing. It has to deliberately abstain, for example, from prosecuting an official who's entitled to immunity, or from a use of force, or from a certain use of force. Deliberate abstentions can be very relevant to the formation or the identification of customary international law. In the debate in the Sixth Committee, a lot of attention was paid to the conclusion number 15, which is about the persistent objector rule. This was also one of the controversial provisions within the Commission, with one or two members, including, I seem to recall, the member from Brazil, expressing doubt about whether this was a rule of international law, despite all the evidence that there is for it, and indeed some case law of the International Court of Justice. But it was an aspect that got a lot of attention from states in the Sixth Committee. I have to say, virtually all of them very positive, saying we're glad that you have included the persistent objector rule. Of course, states rather like it. It keeps their freedom of action occasionally, but very occasionally. But just one or two states who have traditionally been cautious about the persistent objector rule, for example, Cyprus and Greece, because Turkey regards itself as a persistent objector to certain law of the sea matters. But very few states express serious doubts about that rule. But it is important in determining the value of something like these conclusions, to see what states said about it in the Sixth Committee. And then what did they do about it? Well, the General Assembly adopted a resolution 73-203, on the 20th of December 2018, and they did a number of interesting things in the resolution. Firstly, they took note of the statements in the Sixth Committee. So they emphasized themselves the importance of the statements in the Sixth Committee. They then took note of the conclusions and the commentaries, and they annexed the conclusions to the resolution. They, in doing so, deleted the word draft, because the Commission always calls its output draft conclusions, but the General Assembly sometimes deletes those words, the word draft, as it did with the articles on state responsibility, for example. So it took note of them, it annexed them to the resolution, and it said that it brought them to the attention of states and all those who may be called upon to identify rules of customary international law, and it encouraged the widest possible dissemination of the conclusions. So I think it's, on the whole, a very positive outcome. I would call it an endorsement, at least in general terms, of the conclusions, though a reference to the statements in the Sixth Committee is very important. Another thing they did in the resolution, interested by the ways and means, the practical problem, how do you identify state practice and opinio juris? They once again encourage states to publish digests and surveys of practice in the field of international law, to support existing publications. I think there are probably some 30 or 40 or 50 existing publications where states publish their practice, but a lot of states don't. And so encouraging states, perhaps collectively. I know the African Union was thinking of publishing some African practice in the field, which would be very welcome. The Nordic states have published practice, or the Baltic states. So that's an important thing which the General Assembly have encouraged states to do. It will be interesting to see how many states pick that up. Can you hear all right still? I saw sort of hand signals. Good. Of course, it's too early to make any assessment of the value of these conclusions. I'm pleased to see that they have been referred to in a number of recent publications, in new editions of manuals and the like. It seems to take a long time, though, for things to get into published form. That's partly because publishers spend so long publishing books. So things that were written in 2018 are only just being published now. That always rather surprises me. The president of the International Court was very complimentary when he addressed the Commission in 2019. President Yusuf said that we'd, done a good job. Have to look at his exact words. He was pleased that we had completed work on the conclusions. The conclusions themselves are being used by the International Law Commission in other topics. They've been referred to quite a bit under the topic immunity of state officials from foreign criminal jurisdiction. The special rapporteur there has referred to the conclusions quite a lot. They're referred to in the first report on sea level rise. That's a new topic. They've been adopted almost word for word in the draft conclusions on jus cogens in certain aspects of those. So they've been influential within the Commission. They've also been quite influential in court cases, at least in England. We had two cases in the English courts, or two judgments recently, one of which said they had followed or tried to follow the methodology set out in the conclusions, and they annexed the conclusions to the judgment, which I thought was very kind of the Court of Appeal in England. That was a case called the Freedom and Justice Party case, involving the question whether a person on a special mission enjoyed immunity under customary international law. And the court spent about 90 paragraphs examining that question and following the methodology recommended by the International Law Commission, and concluded that there was a rule of customary international law under which persons on special missions enjoyed at least immunity from arrest and detention and from criminal prosecution during the period of their time while on the special mission. It's a very interesting judgment, and I would commend it. The Dutch courts earlier this year also had to decide a question of immunity. This was in relation to the immunity of former military officials for official acts that might have been war crimes. And they examined the work of the International Law Commission on that subject, but they also referred to the work on the determination of on the identification of customary international law. So there have been a number of cases already which have used these these conclusions, which is quite helpful, or quite, sorry, not helpful, it's quite gratifying to the Commission and to me in particular. I should say that the Commission were very conscious that they weren't laying down rules. These aren't, I think, rules of customary international law about how to identify rules of customary international law. They're more rules of recognition, if you like. They're not, their normative value is a subject of some debate. And this blog recently by Professor Hakimi that I mentioned, she criticizes us for laying down rules, where we deliberately didn't lay down rules, and we said we weren't laying down rules. We're offering flexible guidance. That's why they're called conclusions. They're not articles, they're not purporting to lay down rules. The Commission's often rather careful what it calls its output, and conclusions is a very neutral term. These are our conclusions about the methodology for the identification of customary international law. Another thing is we were very careful to say that we were only setting out the methodology as it is at present. We weren't saying it should always be this for all time. There's obviously scope for change in the methodology, though I wouldn't encourage it. But we very much tried to describe the current state of international law, the current methodology applied by international courts and tribunals and by states when trying to identify rules of customary international law. Those, for example, who criticized us for saying the practice of international organizations might count, say, that's lex ferenda, that's not the existing law. Show us practice where the practice of international organizations has counted. And the answer to that, we said very clearly, we are stating the existing law. That is our belief as to what the existing methodology is. We're not trying to say what it should be in the future. We're not trying to address what it might have been 50 years ago when people would have insisted on 40 years of practice or whatever these rather rigid, very positivist approaches to the subject were. This isn't the first time that an effort has been made to set out how customary international law should be identified. You may recall that the International Law Association tried to do this in 2000 in the so-called London Statement of Principles, applicable to the formation of general customary international law with commentary. Very much a very similar exercise, but quite a different conclusion in some respects. We found it very useful, this previous work by a purely private organization, the International Law Association, but we differed from it in some respects. A particular one is that in the year 2000, leading up to it, we get some interference. The International Law Commission, the International Law Association had great difficulty with coming up with a conclusion or principle about General Assembly resolutions. That was very controversial in the 1970s and the 1980s. By the time we were working on it, it was much less controversial. I think there was general acceptance that General Assembly resolutions may include important evidence of the opinio juris of states. They might even reflect the practice of states, but one has to approach them with very considerable caution. We'll have noted that recently the International Law Commission, the International Court of Justice, gave a lot of weight to General Assembly resolutions in the Chagos advisory opinion, considering the question of the right of self-determination and the specific question, when did the right of self-determination become a rule of customary international law? Very interesting debate. I don't think that they took a different position from that which we find in the International Law Commission's conclusions. I may disagree with the way with their conclusion, but the methodology, I think, is impeccable as always. So just to say how we went about the task, because it's quite interesting. There's very little or relatively little material that one can look at to determine what the methodology should be. We first tried to look at state practice, and there is very little state practice or statements by states as to what the methodology should be. Occasionally in court proceedings, they may say things. They said quite a lot in relation to the ICRC's study on customary international humanitarian law. There were certain criticisms of that from the United States, the United Kingdom and others, which gave an indication as to what they thought, how they thought rules of customary international law should be identified, but very little state practice. We then looked at decisions of courts. And of course, there was a lot. There's a lot of guidance in the various decisions and even in some of the separate opinions of the International Court of Justice and of certain other international or regional courts, but especially the International Court of Justice. And also there's some guidance from some national courts. There are some really interesting national court decisions, including historic ones, like those of the US Supreme Court in the 19th century, that give guidance. On the whole, I think that the Commission's work is based more on the work of the International Law Commission than on anything else. We also looked for guidance at academic writings, and there are some very interesting writings on the subject, particularly for me, because he was my teacher, Professor Clive Parry at Cambridge, his book on the sources of international law, and then much more recently, Hugh Thirlway's book on the sources of international law contain very interesting materials, but so do a lot of other writers, and particularly the various textbooks all have a section on this, and some of those are very useful and give very useful guidance. Interestingly enough, the very fact of the Commission taking up this subject led to states expressing views about it. So when we started in 2012, there was very little material from states, very few statements by states about how to identify customary international law. By the time we finished in 2018, we had a massive indications from states about what they thought. And I have to say there were some very useful and very thoughtful statements made in the Sixth Committee by countries from all regions of the world in the debates in 2015, 2016, and then again in 2018. So the very fact of taking up a topic leads to practice and information, if you like. You saw the same with the law of the sea in the 1930s. The fact that the League of Nations decided to study the law of the sea and have a codification conference, a failed one at that, even so, led to states submitting their views on the customary international law of the sea. So the very fact of taking up a topic actually creates or stimulates state practice, if you like. So I think that by the end of the project, we had a lot of information, a lot more information than we had at the start. I'll now just talk very briefly about some of the other more difficult issues within the text. Or firstly, the text overall of the conclusions. They start with a statement, a very clear statement of the two-element approach. And this may seem a statement of the obvious. I think it's rather good to state the obvious from time to time, because so much writing is trying to destroy the obvious or take it apart. So the very fact of stating the obvious is useful. One of the more interesting criticisms of the two-element approach from, for example, Professor Hagenmacher in Geneva, is that it's ahistorical, that in Article 38(1)(b) of the Statute of the International Court of Justice, which of course refers to international custom as evidence of a general practice accepted as law. At that time, although you have the reference to practice and you have the reference to accepted as law, they were thought of as a single exercise. They weren't divided into two elements. It was a general practice accepted as law. That may be so. And it was only the International Court of Justice in the Lotus case that then split the two and said, firstly, you have to look for practice, then you have to look for opinio juris or acceptance as law. And it's very interesting, that debate. He's right, I think. He may well be right. But the fact of the matter is that since the Lotus case, international lawyers generally, the International Court and other international courts have always, I think consistently, the practitioners among them anyway, said you have to have these two elements. So the endorsement of the two-element approach, I think, is an important, if pretty obvious, factor that comes out of the conclusions. They're then divided up. We have a section on what is a general practice. I've already mentioned the most interesting aspect there, which is that under certain conditions, general practice may include the practice of international organizations. Interestingly enough, in 1920, those who drafted the statute did not say state practice, even though some of the proposals were to say the practice of nations. They said practice. So it leaves open the possibility that this is also the practice of other international persons, and primarily of international organizations. We then said that practice must be general. That, of course, is essential, but impossible to quantify. And in the commentaries, we've given some of the key statements from the International Court of Justice, which try to specify what is meant by general practice. But one important point is we said that provided the practice is general, no particular duration is required. As I mentioned earlier, in the old days, states used to say, well, unless something has been there from time immemorial, or unless the practice has been around for 40 years, it can't have become a rule of law. That's obviously not the case. We had the rather rapid development of customary law on the continental shelf, the even more rapid development of customary international law on certain outer space matters, even leading Professor Bin Cheng to refer to instant customary international law, where we say there's no such thing as instant customary international law. That's a that doesn't make sense, because custom has to have, practice has to have a certain duration. You have to have one or two or more examples. It can't be instant. But we did say no particular duration is required. And then the next part, part 4, deals with acceptance as law. The most, perhaps in a way, the most interesting part is part 5, which tries to just look at certain materials which are particularly significant when you're trying to identify customary international law. The first is treaties, where essentially we took the language of the court from the North Sea Continental Shelf case. The second, conclusion 12, are resolutions of international organizations, which is very cautious, but was not, somewhat to my surprise, controversial. The third specific material are decisions of courts and tribunals. There, a very interesting point arose, which was whether the decisions of national courts, which are obviously part of state practice, whether they can also be used as materials to assist in the determination of a rule of law. Can you use national courts as well as international courts? I think, to me, it's obvious that you can. A good decision, a well-reasoned decision by a national court can be as valuable as a decision of the International Court of Justice. You look at the schooner exchange in the United States or other important cases. But the French, for example, or certain French professors, I don't know if there's any listening, tended to say no. It's only international decisions that's being referred to in Article 38(1)(d) of the International Court Statute. I don't believe that's the case. I don't know why, particularly in France, some people seem to think that. Maybe it's because French decisions never have any reasoning, and so they don't regard French decisions as relevant. But that's not true in many of our countries. Then the fourth conclusion of specific materials is teachings, where we thought long and hard. We tried to change the language of the International Court of Justice, which is rather old-fashioned, and we came back exactly to the language of the statute of the International Court of Justice. Teachings seem to us more general than writings, because it includes video teachings, things that are not written, but also it has a certain solemnity to it that writings doesn't have. We tried to come up with something better than the most highly qualified publicists, which is very odd language, particularly to an English-speaking person. I only realized in the course of this exercise that publicist didn't mean a sort of journalist or something like that, but it means a public lawyer, somebody who has studied public law, publiciste in French. Well, that's not quite right either, because we don't have public lawyers so much in England. We tend to just regard ourselves as lawyers. But anyway, teachings of the most highly qualified publicists, that's also a problem. Why the most highly qualified publicists? Well, I think that's not a good phrase. What seems to me to be relevant is whether what they write is good, not whether they're highly qualified, but maybe the two go together, but not always. It's really good writings or good teachings that are a useful subsidiary means. And then of the various nations is very important, as I mentioned earlier. You have to look at writings from as wide a range of countries as possible. Just to be very quick on two final matters that I find very interesting. Well, actually, I've mentioned one already, the conclusion on the persistent objector rule, where we repeated that rule. where a state has objected to a rule of customary international law while the rule is in the process of formation, that rule is not opposable to the state's concern if it maintains its objection. And then we really tried to limit that rule because it's very exceptional, but it does happen occasionally. And we said the objection must be clearly expressed. It must be made known to other states, and it must be maintained persistently. So you have to keep repeating it from time to time as occasion demands, or at least maintain it persistently. So, as I say, that proved popular with states. I think it's also useful what we've done because it limits it. It means you can't just say, well, we've never accepted this rule. You've got to show that you've expressed that very clearly, publicly, made known to other states, and persistently, to be a persistent objector. And as you know, often people start off as persistent objectors, but very rapidly give in and come along to and become bound by the rule of customary international law. And then finally, there's a conclusion on what we call particular customary international law. This is sometimes referred to as regional customary international law, or local, or bilateral, or whatever. But we thought the word particular captured it better than these other things, because it can be regional, it can be sub-regional. There was a lot of talk about Latin American customary international law quite a few decades ago, but also in certain fields like diplomatic asylum. It's was argued in the asylum case that there was such a regional customary international law or sub-regional customary international law. So anyway, we accepted that there could be such a form of customary international law, as the International Court has said. It's fairly unusual, I would say. One interesting question, and this was a bit controversial in the Commission, is whether you can have particular customary international law that doesn't have a geographical limitation, that is among states from different geographical regions. And one possible example in the past would have been socialist customary international law, which may have been mainly in Eastern Europe and parts of Asia, but would have also included Cuba, perhaps. So not really regional. It's more an interest group. It's more a particular way of looking at the law. So we did say that a rule of particular customary international law, whether regional, local, or other, and the or other was meant to cover, for example, non-regional, non-geographic rules of customary international law. That was controversial because some members of the Commission, one or two, said, but give us some examples. There's no practice of this. You've shown nothing to establish that you can have other non-geographically based rules of customary international law. To which some of us said, no, but there might be, so let's put it in anyway. We don't have to show evidence for every single thing. It's obvious that there could be, which wasn't a very good argument. But anyway, we got away with it and it's there. And I don't think that's actually particularly controversial, though it was within the Commission. I've spent more time than I meant to. I think it would be good for me to stop now and listen to questions.
Oh, okay, Professor. Thank you very much for this very important lecture in the beginning of works. I'm so sorry to call you all the time, Professor. This is what I mean, a vicious way in the academy. I'm so sorry. Actually, it's extremely important for us to listen. A practitioner, mainly working in the International Law Commission, and I'm so sorry again.
No.
Sir Wood, and you are also a sir, and I'm calling you Mr. And I'm
that's
so
fine.
sorry.
That's not a problem. Call me Michael.
Okay,
Maria,
well, Michael.
Michael.
Okay, thank you. Well, it was a really important approach, in very, very sophisticated approach, and we need to listen you and make some reflections about this theme and how to work with this problem of how the International Law Commission can interfere in the behavior of the states in this international law, in the international relations ambience. I was with a problem here because we are in the domestic way working, and so I had this neighbor who started hitting the wall and my dog barking. So I had to use my headphones, and I lost a little bit of my attention. I'm so sorry. I know that you saw it. Well, let's move on with the questions. We have some questions here, and I would like to ask you to answer for us. Okay. Can I begin with the questions, Professor?
Please.
Yes, okay. Please. So we began this morning. Oh, all right. Yes, I know you can.
Okay.
We began this morning with Sarah asking you the first beginning of the morning for us, the morning here, but the beginning of the afternoon for you. I think so. Sarah asked here, good morning, Sir Wood. I would like to know your thoughts on the possible impact that the U.S. Supreme Court judging on JAM versus IFC could have on affirming customary law of the International Organization Immunity. Thank you.
Well, I haven't studied the JAM case in detail, but from what I understand, the decision of the Supreme Court is really about US law, about the US law on the immunity of international organizations, and about the particular provisions that apply to the IFC. So I think that it probably doesn't have any influence on customary international law in this field. I have to say that the customary international law on the immunity of international organizations is a subject I'm very interested in, because I wrote a long article about it on the instructions of Professor Blocher from the University of Leiden, who said, we're having a conference, you must write about this subject. And I'd never thought about it, so I did a lot of work. And my conclusion was that international organizations do not enjoy immunity under customary international law. It's only by virtue of their treaties that they have immunity. Of course, there are many treaties, but then there are cases where states are not parties to those treaties. And I've tried to think, for example, if somebody were to sue the World Health Organization in a state where there's no treaty, would the World Health Organization have immunity under customary international law? It's just an example I pick out of nowhere. And it's not a real problem I've had to face, but I just thought it would be an interesting study. So that's a short answer to that question.
Okay. Thank you. All right. The next question is from Rodrigo Franco. Sir Wood, what is the whole customary law place on assuring the judiciality of the ILC drafts which were not transformed into conventions? In the ICJ, for instance, the articles on state responsibility.
Well, that's an excellent question, Rodrigo. because
Yes,
it's
one of the points.
Something which I meant to say in the talk, but didn't, but forgot to have time to. The value of the output of the International Law Commission can be very great. Even when it's not referred to, the International Court often uses the language from the International Law Commission. But now more and more it refers to it in the case of state responsibility, for example, and the responsibility of international organizations. In the course of this exercise on identification of customary international law, the question arose, what should we say about our own product? We've talked about treaties, resolutions, judicial decisions, and writings, but what about our own product? Surely that's very important, say people. And in my reports, I said, it's just a form of writing. It's a kind of collective writing, a bit like the work of the Institut du Droit International or the International Law Association. So we should mention it in the commentary under writings. And some members of the Commission were rather shocked. They said, no, we're much more important than that. Look at us. We should have a whole conclusion about ourselves. And I said, no, we really don't want, that'll look very bad if we have a whole conclusion about ourselves. But it is an important matter, I agree. But where to put it? Where to put it? So in the end, if you look in part 5, which is the part dealing with the specific materials, treaties, etc., there's an introductory paragraph to that part. And in the introductory paragraph, we set out what we think of our own product. Okay. And I'll just read it because it's quite interesting, I think. We say, as has been recognized by the International Court and other courts, a determination by the Commission affirming the existence and content of a rule of customary international law may have particular value, as may a conclusion by it that no such rule exists. Then we said this flows from the Commission's unique mandate as a subsidiary organ of the General Assembly to promote progressive development and codification. The thoroughness of its procedures, including extensive surveys of state practice and opinio juris, and its close relationship with the General Assembly and states, including receiving oral and written comments from states as it proceeds with its work. And then comes the really important bit. We said the weight to be given to the Commission's determinations depends, however, on various factors, including the sources relied upon by the Commission, the stage reached in its work, and above all, upon states' reception of its output. So my short answer to Rodrigo would be that it can be important, but to know how important it is, you need to look at what states have said about it. It's no use just reading what the Commission did. You need to see what they said in the 6th Committee, what they've said in any resolution, what qualifications they've made. And for example, in the case of state responsibility, there were some rather clear qualifications by states saying that the provisions about jus cogens are not necessarily customary international law, and indeed the Commission itself said that in its commentary. So it needs a very careful assessment. One shouldn't just automatically say, well, the Commission said this, therefore we can say it's the law. Thank you.
Okay. Thank you. Thank you. Very, very interesting. This is the one of the main important problem for us teachers of international law. the problem of the use cogents and how to realize it in the reality of the international relations of the states and this environment.
Yes.
Very interesting approach. Okay, and now we have Vinicius. Vinicius is asking, Professor, not Professor, Sir Wood, how to avoid the international customary law reflects only international practices from the Western world. Do you think that the formation of this law is biased by a certain moral?
Right. Well, one other controversial matter in the Commission's work on this topic was what to say about specially affected states. If you remember, in the North Sea continental shelf case, it said that the practice has to be general, but it also has to include the practice of specially affected states. And that's often taken as a reference to the big states, maybe the permanent members of the Security Council. But it's not actually what it's saying. It's saying specially affected states. You have to see which states are affected. So the customary international law on passage through international straits would depend very much upon the practice of the states bordering the straits and the major shipping company states whose vessels are relying upon passage through the states. So it's not just the most important, the biggest states. So that's my answer in a general sense, but the question was more about Western states. I think there is a problem, which we're all very conscious of, that the practice of states tends to be published more by the Western states. The United States is very, very good at publishing its practice, volumes of it, and we all look at it and we all find it useful. That makes the United States very influential. Other countries, particularly perhaps the European ones, do that too, but it's also done by other countries, and they should be encouraged to do it. And it's a big job, it's a difficult job, but nowadays practice is available from all around the world. And this document I mentioned at the beginning that the Secretariat have published, Ways and Means for Identifying Customary International Law, deals with the practice of 190 states or international organizations, and it lists the websites where you can go to. So I don't think it's the case that customary international law is dominated by the practice of Western countries. I mean, one would have to go through different areas, but if you look at the law of the sea, the developing countries, particularly the Latin American countries, if I may say so, had a huge influence on the law of the sea through their practice, through their activity at the Law of the Sea conference, but especially through their practice. And the modern law of the sea is largely written by developing countries and by the Latin countries, I would say, or large parts of it are. So I think it's a bit of a caricature to take the view that this is just a Western thing. I mean, that's what the Soviet Union lawyers said immediately after the October Revolution. They said, we don't believe in customary international law. This was just written down by the capitalist states. But they very rapidly came round to saying, actually, we agree with it and we find it quite useful and we can use it, which is exactly the same position that the newly independent states took in the 1960s and 70s. They said, we can't be bothered with customary international law. Why should we accept it? We had nothing to do with it. But they very rapidly came round to accepting it, and they can influence its future development. Thank you.
Yeah. Okay. Thank you. Maybe this is a historical view of the international law that in the past it was centered in the Europe law. Maybe we have to change this situation. Oh, now we have Flavia. Flavia is asking, Sir Wood, I would like to know your opinion about the importance of customary international law in the implementation of humanitarian law and its current challenges faced by the international society.
Well, I think it's very important indeed, because, as you know, most of the treaty law in the case of international humanitarian law, in the sense of the law of armed conflict, relates to international armed conflict. We're faced these days with so many non-international armed conflicts. The application of customary international law to what's going on in Syria now is immensely important, determining the law relating to detainees and the like. It's hugely important. I think the ICRC did a very good job, and they're continuing to do a very good job by keeping it up to date with their study of customary international humanitarian law. So if it's that sort of humanitarian law, I think the answer can only be that it's very, very important. There are particular problems, but they're greatly helped by the very good work that the ICRC is doing. And that really is, to go back to the previous question, worldwide. They're not just looking at the practice of Western states by any means. If the question is more about international human rights law, then I think that's more difficult. There are so many treaties. States are bound by these treaties. The mechanisms relate to the treaties. But undoubtedly there is customary international human rights law. But what its exact content is difficult to say sometimes, given that the treaties vary among themselves, given that the judgments of the various and decisions of the various international bodies vary from region to region, as well as more generally. So I think there is a problem with international human rights law. It undoubtedly is important, customary international human rights law, in my view, but it's not as clearly or as well developed as customary international humanitarian law. And then, of course, you get the intersection of the two, which is where I give up.
Yes. Okay. All right. So we have three more questions, and then we have to finish, unfortunately, our lecture with Sir Wood. Now we have Fernando. Fernando is asking here, Sir Wood, how can the general practice of certain norms, such as the prohibition of torture, be ascertained given the often lack of consistent practice in that regard?
Right. Well, that's a question that's often asked, and rightly so. I think there one can assess the customary law nature of it by looking at all the other practice. There are cases, unfortunately, where torture is practiced. There are very many cases where states condemn that. Even the states that practice it condemn it. So I think that it's easy enough to construct a rule of customary international law based upon the very widespread acceptance of the UN Convention on Torture and other treaties. One can always also bear in mind the very helpful comment by the International Court of Justice in, I think, the Nicaragua case, saying that the fact that rules are broken doesn't undermine their status as rules, doesn't undermine the general practice. And they were talking there about the use of force by states, but the same can apply in the human rights field. It is one of the problems with customary international law of human rights, but I don't personally think it's insurmountable.
Okay. Thank you. Okay. Let's move on. Can we move on? Okay.
Yeah.
Yes. Okay, now we have Barbara asking, good morning, Sir Wood. I'd like to know to what extent the refusal of a state to follow a recognized custom should be regarded a breach of international law or a step on the evolution and change of such custom?
Ah, yes. Very good question. Well, it could be both. You have to break international law to change it.
Yes.
I mean, obviously, this is a really difficult question. I'd have to give a whole lecture and I'd have to think about it first. In the case, this exercise of the Commission was very limited. It's the identification of rules of customary international law. We did not seek to discuss how rules of customary international law evolve, how they develop, which is a much more sociological thing. The original title of the topic, which I came up with, was indeed Formation and Evidence of Customary International Law. And the French member of the Commission said, you can't possibly deal with that. We should talk about the identification or the determination of rules of customary international law, because if we get into the whole question of how they're formed, we'll be here forever. You know, that's really, really difficult. Looking at all the material sources, I think you'd call them, of rules of law would be very difficult. It's enough to focus on the rules of recognition, if you like. But you know, obviously there are very obvious examples. If you take the 3-mile territorial sea, let's assume that there was a rule of customary international law that you couldn't have a territorial sea of more than 3 or 4 miles. Well, many states broke that. Eventually, they settled on 12 miles. But were they breaking it in the meantime? Actually, it's really as much a matter of opposability between pairs of states, that particular rule, and you get the United States saying we won't recognize 12-mile limit. We'll keep sailing up to 3 miles. So as between a state with 3 miles and a state with 12 miles, probably the 3 miles was the law for a long time. But as between 2 states with 12 miles, obviously they couldn't object to the 12-mile system. So international law, at least in the law of the sea, becomes very much a bilateral matter. You may say that undermines the whole notion of customary international law. It certainly is a difficult question, and perhaps a good place to end, unless there's another question.
Okay, all right. Yes.
The problem with this format is that the people who ask the question don't get to come back and say, you haven't answered my question.
Yes, yes, but she adds something here. She said, I'm thinking about Italy's position after the jurisdictional immunities case and the persistent objector situation. Thank you.
Right. Well,
now she was more specific.
Yeah, well, on that, Italy's position was outrageous. Of course, the position of its courts, but at least they said we're only applying constitutional law. We're not questioning the decision of the International Court of Justice.
Okay.
And we're just not obeying it because our constitutional law requires us to do what we do. And the Italian government, if you remember, although it argued the case, it actually disagreed with its own argument. It took the view that the law, that Germany had immunity. So it's a really interesting case. There are so many of these interesting cases. And it's not only Italy that has had problems of this nature. Thank you.
Okay, thank you. And now the last question we have here for this morning, Lucas is asking, and Sir Wood, I would like to ask what's the function of General Assembly resolutions in the formation of customary international law, and whether all resolutions should have the same weight. And he also adds, And if they have different weight, what is that provides this difference?
Yes. Well, that's quite a big question. I could answer very simply by saying you should read conclusion 12 of the International Law Commission, and particularly its commentaries, because there we make it very clear that it's only in very specific circumstances that provisions of a resolution, not necessarily the resolution as a whole, might be significant to determine a rule of customary international law. I mean, we all know that most resolutions of the General Assembly are voted through on political grounds. They're not necessarily the views of the state reflecting its opinio juris. Sometimes they may be, for example, the Friendly Relations Declaration of 1970, which was negotiated over 6 years and was adopted expressly as a statement of rules of principles of customary international law in the very important fields it covers. But often resolutions are adopted by a vote.
Yes.
If there are significant votes against, then it's very unlikely that they could reflect customary international law. When they're adopted by consensus, you have to see what kind of a consensus it was. Were there lots of statements saying we don't really like this? Were they even purporting to be a statement of customary international law? One example I find quite amusing, but I'll get into a lot of trouble for saying this. If you look at the resolution on principles, the rights of indigenous peoples declaration from 2007, in the preamble, it actually says, wishing to adopt the following declaration as an aspiration. So it's saying on the face of it that it's not laying down the law. This is an aspiration.
Okay.
Well, some of it may be, and quite a lot of it probably has since then, though there were some votes against. 4 states, the 4 with the most indigenous people, voted against it. They may have come into line more recently and accepted it, but it's very subtle. And my short answer to the question is no. You have to look at each individual provision of each resolution.
And he also adds something to this question. He would like to know whether you see there can be an impact of intertemporal law in the formation of customary international law based on state practice, contrary to an international treaty.
That's quite a difficult question.
Yes, it is.
Put it politely. I mean, obviously, the intertemporal law is the intertemporal law. You have to weigh practice in the context of the time when it took place. So all the practice from the 19th century for colonization, for invasions, for this, that, and the other, clearly doesn't carry weight for now, if that's the sort of intertemporal law. I don't really see a particular issue. Obviously, practice and opinio juris have to be weighed up in the context of the time when they take place and their relevance. Well, the other thing is obviously a treaty may codify or reflect or become, its rules may become customary international law, like much of the law of the Sea Convention, but that doesn't stop new customary international law developing that may even be contrary to the treaty. So one has to look very carefully at post-treaty customary international law.
Okay, thank you very much. So, Sir Wood, we finished this fundamental lecture for international law. Thank you deeply once again for your participation, and we hope to see you in person here in another occasion here in Brazil.
I'd very much like
to enjoy
that.
our sun.
Yes, Thank you very much, Maria, and
Thank
I
you.
certainly hope to come to Belo Horizonte
Yes,
again.
please.
I have been once.
Yes, it would be great for us.
On another occasion. Thank you very much
In another
indeed.
occasion.
And
Thank
goodbye
you
to
very
everyone.
much.
Thank you for your patience.
Thank you. Bye-bye. Thank you.
Bye.
It was not a patience. It was a pleasure.
Bye-bye.
Bye-bye.
Hello, everyone. Welcome to our Thursday morning lecture at the International Law Program from the International Law Center. My name is Gustavo Vieira. I teach international law at the Federal University for the Latin American Integration here in Brazil, in Foz do Iguaçu. And I'm very honored to be with you today and to be the moderator of our distinguished speaker, Professor Concepcion Escobar Hernandez. And I will try to be short on this, on her curriculum, and very incredible curriculum. She holds a degree and a PhD in law by the Complutense University of Madrid, chair in public international law of the National Distance Education University, UNED, where she is a professor nowadays. And she's member of the International Law Commission by the United Nations. So those are very distinguished items in her curriculum, but she's also professor of international law at the Diplomatic Academy of Spain. She also is professor of the University Institute of General Gutierrez Melado, and of the Center of International Studies of Humanitarian Law by the Spanish Red Cross. She has been part and head of several Spanish delegations before international organizations and conferences, of which the Rome Conference on the Statute of the International Criminal Court and the Kampala Conference on the amendment of the Rome Statute, of which she was president of the drafting committee, are worth mentioning. So those are very interesting topics. She is also dedicated in the following matters: immunities in international law, international human rights law, international criminal law, international tribunals and settlement of disputes. And she's also a member of the Scientific Council of the Elcano Royal Institute of International and Strategic Studies. So, Professor Concepcion Hernández, muy bienvenida a nuestra clase de Derecho Internacional. Es un placer estar con usted. And she's going to work with us today the issue of immunity of state officials in international law. So, the International Law Commission is developing this issue, and Professor Concepcion is in charge in this developing in international law. And just to remember you, we have usually in the international law course this issue of immunity of states. And this has long development in international law. And this is the topic that we are going to here today. Professor Concepcion Hernández, this virtual floor is yours. Welcome.
Thank you very much. I hope that you are hearing me. Yeah, okay. Thank you very much. First of all, I would like to thank the Sedin and in particular Professor Temer for the kind invitation given to me to participate in this course of international law, which is a very well-known course in the Americas. It is my pleasure and my honor to participate in that edition. And I very much appreciate the fact that you have been you have allowed me to choose choose the topic, because that has permitted to me to speak about one topic which is very important for me, in particular because I can speak on my capacity of a special rapporteur of the International Law Commission on immunity of state officials from foreign criminal jurisdiction. Thank you again to Professor Vieira for your kind presentation, for your kindness in using Spanish language in the introduction. And I can understand Portuguese, but I can speak Portuguese, but at least I can say muito obrigada. Good morning to everybody. I will start with a brief presentation of my topic today. Let me start by underlying the idea that immunity has always been considered by international law from the perspective of sovereignty as a tool to protect the sovereign prince, first in the past, and to protect the state's sovereignty afterwards. From this perspective, the principle par imparem not ab imperium is the most common rule alleged before domestic tribunals in order to claim state immunity. However, a great evolution has taken place during the last century regarding the law of immunities. One of the most remarkable new trends has been the progressive recognition of a kind of immunity, named also sovereign immunity, with regard to the head of states and other state officials. This trend has been developed alongside with a limited process of codification of the law of the immunities and a new interest from international courts, in particular International Court of Justice, the European Court of Human Rights, and the International Criminal Court on the institution of immunity in international law. In this framework, I would like to draw your attention about the emergence of a new and deep process of reflection about immunities at the beginning of the 21st century. This reflection focused mainly on the following issues. Whether it exists only one sovereign immunity, the state immunity, or if there are a coexistence of various kinds of sovereign immunities, so immunity of state immunity and immunity of state officials. Second, the identification of the legal basis for sovereign immunities, including whether there are one or more bases. Third, which are the scope of sovereign immunities, including the possibility of identifying different scopes depending on the various types of immunity. And fourth, the relationship between immunity and legal values and principles of international law, in particular, the relation between immunity, international crimes, and serious breaches to human rights and international humanitarian law. Immunity of a state official is in a central position in the new scenario of immunities. This type of immunity became a privileged laboratory for analyzing and identifying the new trends arising around a classic but changing legal institution. As you can imagine, it is impossible to address all the issues related with the immunity of state officials in only 2 hours. But I will intend to address the most relevant issues. So that I plan to speak today about the origin and evolution of the immunity of state officials and about the main characteristic of this kind of immunity. And tomorrow I will deal with the work of the ILC on immunity of state officials and the relationship between the immunity of state officials and international crimes. Moving to the first issue, I would like to recall that the treatment of immunity of state officials in international law has experienced a very significant evolution, which could be qualified as a round trip. From a historical perspective, immunity in international law appears as the immunity of the prince, who, as the holder of sovereignty, cannot be subject to the courts of another state, not to other coercive measures. Thus, immunity is, in its own origin, a personal immunity of the prince. In any case, immunity is based on sovereignty, and therefore, when sovereignty ends to be a personal attribute of and is considered as element pertaining to a state itself, immunity becomes the immunity of the state, free from any personal or individual component. This new approach will be reflected in several decisions taken by national courts through the 19th century, and as a result of the expansion of the scope of international relations, the interest of international law to immunity has been deviated from the immunity of the sovereign prince to the immunity of the sovereign state, even from the perspective of codification. So the adoption of the European Convention on Immunities or the adoption of the United Nations Convention on Jurisdictional Immunities of State under Properties are very clear examples of this development. However, the issue of immunity of state officials continue to be present at international level nowadays. I would like to offer you some examples that can illustrate that assessment. First, in the context of the two world wars, there were some attempts to prosecute Kaiser Wilhelm, First World War, and the Nuremberg and Tokyo courts were created. In both cases, immunity of a state official has been alleged. Second, immunity has been continuously alleged to prevent national courts for exercising their jurisdiction over head of state, head of government, foreign minister, and other high-level state official. See, for example, the Gaddafi and Anobian cases in France, the Gerodia and Sharon cases in Belgium, or the Pinochet, Castro, and Kagame cases in Spain. Third, some national courts have decided not to exercise their jurisdiction in respect of certain acts, including torture, committed by senior state officials on the grounds that they were protected by state immunity. See, for example, Al-Dassani and Jones cases in the UK. Other tribunals, on the contrary, have not recognized such immunity. For example, and it is an example also from UK, the Pinochet case. Four, we have to take into account that some courts have also ruled on the immunity from civil jurisdiction of state officials, in particular in those countries which legal system permit to claim damages based on breaches of international law committed by foreigners, including state officials. See, for example, the Alliance Tort Act in the United States. Five, some national acts have made reference to the immunity of a state official of the foreign state, either with relation with the immunity of a state, the traditional immunity of a state acts, in particular in the Anglo-Saxon countries, and in regard with the process of implementation of the Rome Statute of the International Criminal Court. Sixth, the immunity of jurisdiction of a state official has been included in several treaties. And seventh, the International Court of Justice, the European Court of Human Rights, and the International Criminal Court have ruled on several occasions on the immunity of state officials, always from the perspective of international law. In short, the immunity from jurisdiction of state officials continue to form part of the law of immunities in contemporary international law, although their own characteristics are far from the original immunity of the sovereign prince. This modern manifestation of the immunity of a state official is undoubtedly an issue of great interest to states and to the international community, which has also reached a special significance since the 80s of the last century, when the in particular with relation with the moment when the particular problem of immunity from criminal jurisdiction and its possible impact on impunity from international crimes begins to arise as a very important issue. This increasing relevance of the immunity of state officials in international law has had as a consequence the adoption of new rules of international law, most of them conventional rules. At the first stage, the issue of immunities of a state official was not considered in itself, but as a component of the general regimes applicable in the field of diplomatic relations and in the field of the armed force stationed abroad. Regarding the immunities in the field of diplomatic and consular relations, 4 treaties must be mentioned. First, the Vienna Convention on Diplomatic Relations. Second, the Convention on Special Missions. Third, the Vienna Convention on the Representation of a State in their relation with international organizations of a universal character. And fourth, the Vienna Convention on Consular Relations. All of these conventions have been adopted on the basis of draft articles elaborated by the International Law Commission. Thus, the legal regime applicable to the immunity of state officials set out by them follows the same model. The main characteristics are the following. First of all, there are a multiplicity of individuals covered by immunity. Second, there are different immunities regime. Third, immunity can be alleged before civil, criminal, or other kind of domestic jurisdiction. And fourth, the legal basis of immunity is foreseen as the protection of the sovereignty of a state, and its purpose is to protect the function of the state representatives abroad. The Vienna Convention on Diplomatic Relations could be considered as the more general and comprehensive of this convention, and for this reason, I will limit my following comments to it due to the time restraint we have. Under the Vienna Convention, immunity applies to diplomatic agents, the head of mission and other diplomats, but also to other categories of individuals linked to the diplomatic mission, in particular the administrative and technical staff, the service staff, and finally to the members of the family of diplomatic agents. Persons in all these categories are granted some form of immunity from jurisdiction, even if the scope of that immunity varies for each category. The immunity extended to diplomatic agents is the broadest, and the immunity extended to members of the service staff is the narrowest. The common element in the recognition of the immunity of these persons is that they perform certain functions in the service of the sending state, with which they have a formal connection, regardless of the legal nature of that connection. That could be whether statutory or contractual. There is no doubt whatsoever as to the nature of this function, as they are referred to in the Convention. They are public and official functions and activities. In short, they are all performed for the purpose of carrying out the functions of a diplomatic mission, which are a clear manifestation of governmental authority. It should be also be borne in mind that the Vienna Convention on Diplomatic Relations accords particular importance to the special connection between the aforementioned categories of persons and the state, namely nationality. Although that connection is not critical for the performance of diplomatic, administrative, technical, or service functions in a diplomatic mission, it has a bearing on the regime applicable to immunity from jurisdiction. In short, it is the connection with the state and action on behalf of the state and the performance of official activities for its benefit through the diplomatic mission that make it possible to identify, to recognize to state officials some forms of immunities. The only exception to this rule is the case of the family of the diplomatic agents, who, even if they don't exercise any activity or function on behalf of the state, enjoy some kind of diplomatic immunity in order to protect the independence of the diplomatic agent. At any rate, although the family of a diplomatic agent enjoys immunities, they cannot be qualified as state officials, of course. However, the immunities regime set up by the Vienna Convention made a clear distinction between diplomatic agents and other members of the mission. For diplomatic agents, the immunity is linked to the person in charge of the exercise of the true functions of state representation. As a consequence, the scope of immunities they enjoy are designed in a broad way. So, in accordance to Article 29 and 31, the diplomatic agent, first, he enjoys immunity from criminal, civil, and administrative jurisdiction, with some limited exception, of course, but related only to civil immunity. He is not obliged to give evidence as a witness. No measures of execution may be taken in respect of him. And finally, his person shall be inviolable, and he shall not be liable to any form of arrest or detention. In addition, immunity of diplomatic agents covers both the acts performed in an official capacity and their private acts, and no limitation or exception to immunity from criminal jurisdiction exists. However, it must bear in mind that this kind of immunity is applicable only during the term of office of the diplomatic agent. When this term ends, immunity remains only with regard to the acts performed in an official capacity. The scope of the immunity enjoyed by other members of the diplomatic mission is more reduced, being limited to acts performed in an official capacity. Thus, the Vienna Convention on Diplomatic Relations has established two different categories of immunity linked to person, the diplomatic agent, or to the acts performed, the other members of the mission. Both categories are on the basis of the distinction between immunity ratione personae and immunity ratione materiae, which are well-known concepts in the framework of the immunity of state officials. Moving to the second field, when immunities appears, I would like to say some words about immunity of armed force stationed abroad. This type of immunity has been approached both from the perspective of the state immunity and from the perspective of the members of the armed forces and the civil staff accompanying the troops. Regarding the immunity of members of armed forces, it has been addressed always by conventional rules contained in bilateral treaties, or more recently in the agreements on the statute of forces, the SOFAs. Due to the specific characteristic of this kind of activity, the issue of immunity usually doesn't appear always in an express manner, but sometimes under the form of a system of distribution of jurisdictional competence. But at the same time that this convention and agreements have included some rules related to immunity of a state official, it has emerged a customary rule on the immunity of head of state and other high-rank official. It is an autonomous rule devoted exclusively to immunity of state officials. The existence of that customary rules have been recognized in particular in the Convention of Special Mission and in the Vienna Convention on the Representation of State in the relations with international organizations of a universal character. Both conventions declares that the head of state, the head of government, the Minister of Foreign Affairs, another minister or another high-ranking authority of the state acting as a member of this special mission or acting as a mission before an international organization enjoys not only the specific immunities established by convention, but also the immunities that international law grants to those categories of state officials. In addition, the existence of this customary rule has been recognized by the International Court of Justice in the arrest warrant case. More recently, the International Criminal Law has recognized the existence of a customary rule of immunity of the head of a state in the judgment issued on the Jordanian case, to which I will refer tomorrow. And the same assessment has been made by several domestic courts facing the issue whether to exercise or not their jurisdiction with regard to head of a state and other high-rank officials. This customary rule has set up an autonomous legal regime on immunities applicable before both civil and criminal jurisdiction, which relevance in contemporary international law can be denied, although if its scope continue to be uncertain and sometimes controversial, as show the domestic and internal case law and even the works of the International Law Commission and the doctrine, including the Institut du Droit International. This autonomous legal regime on immunities of state officials present some specific characteristics which merit to be highlighted. First, immunity applies to head of a state and other high-ranking state official, but it could be applied also to other state officials in case they have performed acts in an official capacity. Second, the legal regime applicable to different categories of state officials is different, so it must be made a distinction between immunity ratione personae and immunity ratione materiae. Third, immunity of state officials applies from civil, criminal, and administrative jurisdiction. Fourth, immunity of a state official is different to state immunity. And fifth, immunity of a state official must be understood as immunity from foreign jurisdiction, not as immunity from international jurisdiction. I would like to make some comments on the certain some comments about this characteristic, in particular on the following issue. First of all, the distinction between immunity ratione personae and immunity ratione materiae. Second, the relationship between immunity and jurisdiction. And third, the distinction between immunity of state officials and state immunity. I will start with the distinction between immunity ratione personae and immunity ratione materiae, because I think that is one of the main characteristic elements of the immunity of state officials. The distinction between immunity ratione materiae and immunity ratione personae is a classic one, and they are referred also as personal immunity with relation to the immunity ratione personae and functional immunity with relation to immunity ratione materiae. In fact, they are the same, the content is the same, even if I prefer to use the the terminology of immunity ratione materia and immunity ratione persone in order not to provoke a confusion about the nature, the functional nature of any immunity of the state officials. The distinction between both categories has been well established by doctrine on the basis of focusing mainly on the person enjoying immunity, immunity ratione persone, or on the acts covered by immunity, immunity ratione materia. Although this distinction is not defined by any legal test, the analysis of practice permit us to conclude on the identification of three different elements. First, immunity ratione materia applies only to several state officials of high rank level, in particular the so-called troika, and immunity ratione materia could apply to a broad range of state officials. Second, immunity ratione persone covers both private and official acts, and immunity ratione materia covers only acts performed in an official capacity. And finally, immunity ratione materia applies only during the term of office of the state officials, but immunity ratione materia has not a temporal limit. The distinction between immunity ratione persone and immunity ratione materia is not a mere theoretical distinction. On the contrary, this distinction has some important effects on the distinction between immunity of state officials and state immunity, and it is the basis for the establishment of, for setting up of different legal regimes applicable to each kind of immunity of a state official. With regard to the relationship between immunity and jurisdiction, I would like to draw your attention on the fact that immunity and jurisdiction are the two basic concepts it must be taken into account in order to identify the institution of immunity of state officials. Consequently, although the concepts are separate from one another, as currently noted by the International Court of Justice in the arrest warrant case, only the relationship between them explains the content of the institution of immunity in international law. The concept of immunity is by necessity based on the prior existence of the criminal jurisdiction of the state, without which the institution of immunity itself would be meaningless. Consequently, it is first necessary to determine what we mean by jurisdiction. Jurisdiction is a generally accepted term that is an uncontested component of all domestic legal system under which immunity can be invoked. It means the competence for domestic courts and tribunals to settle any dispute or case relative to the interpretation and or application of national law. Thus, it is a concept strongly linked to the judiciary activity. Jurisdiction can be on civil, criminal, or other matter, as I said before. So, as a rule, we can make a difference between immunity from civil jurisdiction and immunity from criminal jurisdiction, on the understanding that civil jurisdiction, immunity from civil jurisdiction covers also the immunities before other jurisdiction different than criminal. Although both of them must be considered as immunity of state officials, some differences could exist between the legal regime applicable to one or another. Finally, jurisdiction must be understood exclusively as foreign jurisdiction, not as international jurisdiction. Thus, immunity of state officials only applies with regard to the domestic courts and tribunals. Like the term jurisdiction, the term immunity is not usually defined in the international instrument that in one way or another have deal with the immunities of a state or its officials or agents, including the United Nations Convention, the Vienna Convention on Diplomatic Relations, and the Convention on Special Missions. Generally speaking, normative practice has in the past tended simply to mention immunity from jurisdiction as one component of the regime of privilege and immunity set out in each of those instruments without defining it. Although it could present us with a nebulous legal concept, the task of integrating this nebulous legal concept is not particularly difficult, since the concept of immunity from jurisdiction was the subject of lengthy discussions, including within the International Law Commission during the travaux préparatoires of the aforementioned instruments. A set of characteristics of the concept of immunity from foreign jurisdiction has emerged, which can be summarized as follows. First of all, immunity prevents a state from exercising its criminal jurisdiction, even though its courts would, in principle, be competent to exercise its own jurisdiction. Second, immunity arises only as a result of the existence of a foreign component, referred to generically as an official of another state. And third, immunity from foreign jurisdiction is by nature mostly procedural, although it is necessary to introduce some nuance in certain cases related to immunity from foreign criminal jurisdiction, to which I will make reference tomorrow. In any case, as jurisdiction is an inherent power of the state, we can draw several relevant conclusions from a methodological perspective with regard to the nature of immunity. These conclusions could be expressed in the following form. First of all, immunity is a limitation or exceptions to the exercise of the jurisdiction by the territorial state. Second, as a limit to a sovereign power, immunity must be understood under theological terms. Immunity is recognized in order to protect values, principles, and interests of the international community, in particular, the equal sovereignty, the free and peaceful exercise of the state functions, and the stability of international relations. The scope and meaning of immunity must be limited to the achievement of the purpose previously mentioned, and exclusively in order to protect the state interest and not the official interest. And finally, the relation between jurisdiction and immunity must be considered in a dialectic way in order to set up a fair balance between the rights and interests of the foreign state, jurisdiction, and the official state, immunity. That fair balance must be identified case by case on the basis of the applicable rules, values, and principles. Finally, I would like to make some comments with regard to the relationship between immunity of state officials and state immunity itself. It should be borne in mind that the immunity of state officials has traditionally been viewed as a form of state immunity and has been conflated with that concept. It is not unusual to find reference in legal practice to the idea that state officials enjoy the same immunity enjoyed by the state. This view has led to the conclusion that the immunity of state officials from from jurisdiction, is not an individual immunity, as it derives from state immunity, the legal regime of which is fully applicable to immunity of state officials. This conclusion is this approach is the outcome of various arguments, including the following. First, immunity from jurisdiction enjoyed by a state official is a consequence of the principle of the sovereign equality of states, as expressed by the phrase par imparem not habet imperium. Second, immunity is recognized in order to protect state sovereignty and ensure that international relations can be carried on peacefully and sustainably. Third, the immunity of state officials is not in fact immunity of the officials, but immunity of a state, as demonstrated by the state's freedom of choice with regard to such immunity, including the freedom to live or waive immunity. And finally, this identification between immunity of state officials and state immunity is based on the idea that bringing suit against a state official in a foreign court is an indirect way of bringing suit against the state when the latter cannot be prosecuted in the courts of a third state, meaning that the official's immunity from jurisdiction serves as a safeguard against frivolous challenges to state immunities and is therefore equivalent to state immunity. These arguments certainly contain valid points that cannot be denied, especially the fact that officials are given immunity from jurisdiction in the interest of the state and in order to safeguard values and principles that pertain solely and exclusively to the state. Even so, the arguments fail to consider other factors that must be taken into account in order to determine how the immunity of state officials from foreign jurisdiction is related to the immunity of the state. In order to find an adequate response to this issue, it is necessary to make a distinction between immunity from civil jurisdiction and immunity from criminal jurisdiction. The link between state immunity and immunity of state officials is more clear and stronger in the case of immunity from civil jurisdiction. However, this conclusion, the stronger link between state immunity and immunity of a state official, is not evident in the case of immunity from criminal jurisdiction. In particular, because the criminal nature of the jurisdiction has two major consequences. First, the object to which the jurisdiction claims in such cases directly relate is the individual. And second, any consequences of the outcome of the criminal proceedings are individual and strictly personal. This creates a direct link between the individual and immunity from foreign criminal jurisdiction. It should also be noted that a state can never be prosecuted in national criminal courts, as any responsibility it may have for criminal acts committed by its official will always be of a civil nature and can only be determined in civil courts by means of a claim for compensation for the harm caused by such acts. That implies a distinction between immunity from civil jurisdiction and immunity from criminal jurisdiction, which must be duly taken into account. From the two elements mentioned above, it must be concluded that immunity of a state official is different from state immunity in particular with regard to immunity from foreign criminal jurisdiction. This assessment is crystal clear with regard to the immunity from jurisdiction ratione materiae, which is individual in nature and distinct from the immunity of state stricto sensu. This is true even though this distinction is not always made with sufficient clarity in the literature and in practice, largely as a result of the traditional emphasis of the state and its right and interest as the beneficiary of the protection afforded by immunity. While the state undeniably occupies a central position in this institution, the protection of its rights and interests is nevertheless an insufficient reason to conclude that immunity of state and immunity of state officials are one and the same, just as identity of purpose, as in the case of state immunity and diplomatic immunity, does not mean that the two types of immunity are identical. Rather, in order to gain a proper understanding of the institution of immunity of state official from foreign criminal jurisdiction, ratione materiae, it is necessary to distinguish between the direct beneficiary of immunity, the state official, and the indirect or ultimate beneficiary of immunity, the state. Immunity ratione materiae is recognized in the interest of the state, which has sovereignty, but it directly benefits the official when he or she acts in expression of such sovereignty. The distinction between immunity of a state and immunity of its officials from foreign criminal jurisdiction is not a mere theoretical construction. It has been reflected in a number of judicial decisions adopted by both national and international courts. Regarding decisions at the national level, it's sufficient to recall the different ways in which the House of Lords, the former High Tribunal in UK, deal with immunity in Pinochet case number 3, in Price-Nasser case, and in Jones case, based on the different nature, criminal and civil respectively, of the proceedings in which immunity was invoked, and on the consequences of that difference in terms of immunity. Of particular relevance is the case Sementar versus Yusuf, in which the Supreme Court of the United States held that a state official cannot be deemed to be included in the concept of a state within the meaning of the Foreign Sovereignty Immunity Act, and that the immunity of such an official is subject to rules that differ from those applicable to the immunity of a state from prosecution in that country's courts. Of greatest relevance are as well the decisions of international courts that have expressed or implied made a distinction between state immunity and immunity of state officials. The International Court of Justice in jurisdictional immunities of state case acknowledged this distinction by affirming that, I quote, "The court must emphasize that in the judgment, it is addressing only the immunity of the state itself from the jurisdiction of the courts of other states. The question of whether, and if so, to what extent, immunity might apply in criminal proceedings against an official of the state is not an issue in the present case." The court also expressed acceptance of the distinction between immunity of a state and immunity of state officials in referring to the way in which national and international courts have dealt with the distinction between civil and criminal jurisdiction and its consequences for immunity and in referring to its own jurisprudence. The European Court of Human Rights in Jones and others versus United Kingdoms have produced a very interesting judgment, who is highly relevant since, as the court notes, the applications refers to a case of immunity which, unlike the one in Aldasani, was brought before the British courts against individuals and not against a foreign state. The court nonetheless applied the traditional doctrine that state immunity applies also to individuals. This conclusion, however, requires a nuanced view, as the court made clear in explaining the legal grounds for its judgment that its decision refers exclusively to immunity in the context of civil cases and alludes to the possibility that a different approach may be taken when immunity is invoked in criminal cases. The differentiation between the immunity of state officials from foreign criminal jurisdiction and the state stricto sensus is still more evident in the case of immunity ratione personae, as an official who enjoys such immunity, a head of state, head of government, or minister of foreign affairs, may do so even in respect of acts which are performed in a private capacity and which thus are not attributable to the state and do not engage its responsibility. In such cases, the immunity of these three officials from foreign criminal jurisdiction for a criminal act committed in a private capacity has no equivalent whatsoever in the realm of state immunity. And yet, even in these cases, such acts are covered by a form of immunity from foreign criminal jurisdiction that is recognized also for the benefit of the state, not of its official. Taking into account the previous consideration, the following conclusion may be drawn. First, state immunity is typically assumed to apply in respect of acts which are attributable to the state alone and for which the state alone can be held responsible. Second, when an act is attributable both to the state and to an individual, and both can be held responsible, two types of immunity can be distinguished: immunity of the state on the one hand, and immunity of the official on the other. And third, the differentiation between immunity of a state and immunity of state officials is clearest in respect of the immunity of a state official from foreign criminal jurisdiction, given the different types of responsibility attaching to the state, civil, and to its officials, criminal, and the different nature of the jurisdiction from which immunity is invoked. Finally, I would like to call your attention on the fact that concluding that immunity of a state official is different from state immunities is not, again, a mere academic issue. On the contrary, because of the autonomous character of immunity of state officials, it is possible to conclude that immunity of a state official is submitted to its own legal regime, including the possibility to apply some exceptions to immunity in several circumstances. Well, I think that I have made all the comments, general comments I would like to give you today with regard to from a general perspective, and I only want to make a final remark. The issue of immunity of state officials works nowadays on a special role in international law, in particular because immunity of state officials are pursued by states as a tool for defend our own rights, our own interests before other countries, and sometimes in order to avoid the so-called intervention in domestic affairs. So immunity of a state official has a very, very strong political component, and I think that it is an issue, and it is a controversial issue both from legal and political perspective. But at the same time, we have to take into account that the issue, the legal regime, or the issue of the immunity of a state official has experienced an important and very interesting change at the end of the last century, in particular because of the development of international criminal law and for the process for setting up an international criminal system, including the establishment of the International Criminal Court. This new scenario has generated a new interest on the immunity of state officials. But these interests are linked with the new purpose of the international community to fight against impunity from international crimes. So it appears a new element that we have to take into account in order to define the legal regime of immunity of state officials. It is in this new context that the International Law Commission is working on the topic of immunity of state officials from foreign criminal jurisdiction, to which, as I said before, I plan to deal with tomorrow. Thank you very much, and I am ready to hear your questions, and I will be my best. I will try to do my best to answer to it. Thank you very much.
Thank you very much, Professor Concepcion Escobar Hernandez. It was very, very clear and very didactic and also deep. Professor Concepcion make a very clear distinction among state immunity and the immunity of state officials, and described the categories to read this important institute of international law and its implications to the geopolitics, to the stability of international relations. The distinction among immunity from habeas personae, habeas materii, the immunities among criminal jurisdiction, civil jurisdiction, administrative implications, and the personal implicated to these immunities, the high-rank officials, the other administrative servants, and the family. So she also mentioned some cases from the ICJ, quoted the European Court of Human Rights, Al-Bassani, and we have several questions, Professor. So I will read it in block of 3 questions each time, and very interesting ones. So first, Luis Felipe Santana asked, I would like to hear from you if, in your opinion, absolute immunities of head of states, especially regarding the human rights violations, is coming to an end in our days. Second, Thais Almeida, good morning, Professor. I would like to hear your opinion about al-Bashir case in the ICC and the political consequences of the court's prosecution of officials, especially in the African context. The other one is from Hannah Leão. Professor Hernandez, could you explain the application of Article 98 of the Rome Statute and its relation with the state officials' accountability under international law? I selected the Article 98 just to quote for you and for our audience. Article 98 of the Rome Statute says, cooperation with respect to waiver of immunity and consent to surrender. 1. The court may not proceed with a request for surrender or assistance which would require the request state to act inconsistently with its obligations under international law with respect to the state or diplomatic immunity of a person or property of a third state, unless the court can first obtain the cooperation of that third state for the waiver of the immunity. 2. The court may not proceed with a request for surrender which would require the request state to act inconsistently with its obligations under international agreements pursuant to which the consent of the sending state is required to surrender a person of that state to the court, unless the court can first obtain the cooperation of the sending state for the giving of consent for the surrender. So I led with these first 3 questions. Professor Concepcion, the floor is yours.
Thank you very much, Professor. I realized that every question are related to immunities with regard to International Criminal Court or with regard to international crimes. But I can understand. I can understand because at the end of the day is the most controversial issue and the most the issue having received more attention from the doctrine and even from the newspapers. Well, with regard to the future for absolute immunities of head of states, in particular, including the immunity for acts which constitute a serious breach to human rights. I think that if we think about immunity of state officials in a strict sense, that means immunity of state officials before national courts, this I can see, to be honest, I can see that this kind of immunity is going to an end. That for several reasons. Tomorrow I will make some comments on that when I will explain the content of immunity ratione personae in the work of the ILC in the work of ILC. First of all, because immunity of head of state is a personal immunity. That means that this kind of immunity covers all acts performed by the head of state, both private acts and acts performed in an official capacity. Well, breaches to human rights could be considered as official acts. It depends, but I to be honest, I know that I am in the minority position, but I think that they are official acts. Because if we consider that this kind of acts are not official acts, how is possible to attribute this kind of acts to a state? And how is possible to obtain the declaration of responsibility of a state? You know, it's a tricky argument. That is the first reason. And of course, there are private acts. That means that if immunity ratione personae covers both private and official acts, to use a short terminology, head of state are covered by any act committed as head of state. That means that the absolute immunity of head of state, from my perspective, is not going to an end. But which is most important for me is to put on the table the following thoughts. It is not relevant if immunity of head of state is absolute. It's not relevant for the protection of human rights or crimes, the fight against international crimes, or the fight against impunity, because the immunity of head of state has a limited duration. Once the head of state ends their term of office, only the act performed in an official capacity could be covered by immunity. So if we consider that this kind of acts has been committed, or has been committed as private acts, the head of state will lose the protection provided by immunity. Even in the case that we consider that immunity, that this kind of acts are acts performed in an official capacity, we are before immunity ratione materia. And with regard to immunity ratione materia, we can establish some exceptions or limits to the protection given by immunity of state officials. One of the most, that is the issue, the most controversial issue now in the work of the International Law Commission, which is the draft Article 7 adopted by the Commission 3 years ago, establishing the list of crimes which are not covered by immunity of state officials. Which are these exceptions? Well, tomorrow we can have a more deep explanation of that, but of course, most of the breaches of human rights are crimes against humanity or war crimes or genocide. So they must be considered as exceptions to immunity ratione materia. Well, of course, the main issue is what happens if the head of state is a permanent head of state, or if the head of state want to continue to be a head of state in order to benefit from the immunity ratione personae. That is a factual issue. It's not a matter of law, it's a matter of fact. And if we look at the practice, we can see how, for example, al-Bashir, who has been fighting for continue to be the head of state, to be protected before against the International Criminal Court, has been diminished, has lost her post of head of state, and at that moment, no protection is covering the al-Bashir, the former president al-Bashir. Well, the second one, for me, for that reason, I think the more important issue is not the permanence of the absolute immunities of head of state, but the most important is to obtain the assurance that the exceptions to immunity ratione materia will exist. Second, with regard to the al-Bashir case, I think that there are there are a great relation with between the second and third question, but I will try to make some comments. Well, the al-Bashir case, of course, the al-Bashir case has had a great incidence in Africa, even in the African countries, and in the African Union. Only I would like to recall only that some African countries called to the African Union to ask any member of the African Union to withdraw from the Rome Statute. Well, it's true that one had decided to retire himself from the Rome Statute, but it has not been agreed. The main state had decided not to go in the same way. But it is true that the al-Bashir case has had an important consequence or could have an important consequence on the new international criminal system, because as a consequence of the al-Bashir case, the African Union has adopted 3 years ago the Malabo Protocol, establishing a new chamber in the African court, a criminal chamber in the African court. Of course, the protocol, the Malabo Protocol, is not in force, but the most important element for me, the most critical decision included in the protocol is that this protocol excludes the principle that no immunities could be alleged before an international criminal court, an international criminal tribunal. Saying in the protocol set up the position to establish that the new criminal chamber will not address any case before a current state official. That is in the opposite side of the International Criminal Court. Well, the risk of the fragmentation of international law related to immunities before international tribunals is there, even if I think that we have to be aware the entry into force of the protocol is not an imminent fact. It will take a lot of time for entering into force. And but of course, the al-Bashir case has had great political, very important, serious political consequences with regard to the court of the International Criminal Court. And with regard to the last question, Article 98 of the Rome Statute. Well, that is the key. The interpretation of this article is the key for determining if immunities applies or not before, or if immunities of state officials has some incidence on the exercise of the jurisdiction of the International Criminal Court. Well, in fact, it has been the interpretation of Article 98. The interpretation of Article 98 has been the core element in the judgment adopted by the International Criminal Court in the Jordanian case. But I have to say that the International Criminal Court, the ICC, has declared that there are a customary rule who exclude the possibility to allege immunity before an international criminal court, to which I can agree. But even if the system of customary law, I think that so Michael Wood will speak about the identification of customary law in the same course. You could put the question to him. He will give you a different answer than mine. But I think that I can accept that there are a general rule of international law avoiding the possibility to allege immunity before the ICC, at least before the ICC. Yeah, but it doesn't mean that because of Article 98. Immunity of state officials could not be alleged before national courts acting at the request of the International Criminal Court. I don't know if I'm able to explain what is my thought about that. Well, the ICC said, well, no immunity could be alleged before the ICC, so no immunity could be alleged before a national court who is cooperating with the ICC. Because at the end of the day, the ICC the court considered that the national domestic court are exercising the jurisdiction of the ICC. Well, I can agree with that, but I think that we can go on this issue tomorrow. But the most important for me, I think that it is impossible to consider the significance of Article 98 without taking into account the Article 27 of the Rome Statute, who is the disposition establishing which made a clear declaration about the impossibility, about the fact that immunity at any rate can block the jurisdiction of the ICC. The only possibility is the ICC is not able to exercise jurisdiction at that moment because of the lack of cooperation, but the ICC don't lose the jurisdiction. Sorry for this long explanation.
Excellent, very, very clear. Just to highlight, also the Rome Statute is not open for reservations.
Of course.
So this is complementary. We have some other questions. The other question came from Leticia Hartel. It would be interesting if Professor could comment on the immunity of the US officials in Afghanistan. But I believe this will be addressed tomorrow. The other question came from Julia Peret. Professor Escobar, what are the exceptions of criminal immunity? Right. And we have also another question that from Leticia Hartel. Professor, what is your view on the Zelaya episode? Specifically on whether the Brazilian embassy in Honduras still enjoyed diplomatic privileges despite of the activities taking place there. This case, Professor, was the case where the president of Honduras was excluded from his territory, and he came back to the Brazilian, embassy and make speeches from the Brazilian embassy. I think it's similar to Assange. So this is also a case where the distinguish among state immunity, diplomatic, the Vienna Convention diplomatic immunities from 61 and well, but I think you can make it clear. Those are also very interesting opportunities to make those distinguishes clear. Professor, it's closing.
Okay, well, with regard to immunity of U.S. officials in Afghanistan, well, I can imagine that you are referring to the recent decision of the Chamber of Appeal of the ICC, declaring that the commission, the prosecutor is able it could be able to start the investigations. I think that is that. Well, the immunity of U.S. officials in Afghanistan could be analyzed from two different approaches. First of all, from the approach of the SOFA, the American forces in Afghanistan are on the basis of a SOFA that covers the activity of all the members of the military operation, and in this case, I think I need to review the test of the SOFA. I don't have here the test, but I think that in this case, the U.S. official could have some kind of immunity, not truly an immunity, but they could be free to be submitted to the Afghan tribunals, but on the contrary, they have to be submitted to the U.S. tribunals, who is not the same. It's not exactly the immunity, but that is not. But there are another perspective, who is the perspective from the International Criminal Court. Regarding International Criminal Court, the issue is the following: the ICC has the capacity to open procedures against U.S. officials stationed in Afghanistan, according with the U.S. the Rome Statute. The answer is yes. The answer is yes for one very easy reason. For an easy reason. The International Criminal Court is competent for exercise jurisdiction with regard to every act performed for every person in Afghanistan, because Afghanistan is a party state of the Rome Statute. Well, there are other rules, but in this case, what does it mean? That is not, if we look at the immunity of state official from the perspective of the ICC, of course, it doesn't exist any immunity which could protect the U.S. officials. Regarding the exceptions are genocide, the following crimes: genocide, crimes against humanity, war crimes, torture, forced disappearance, and apartheid. There are the crimes included in the draft Article 7, adopted provisionally adopted by the ILC, and I will explain tomorrow more about that. They are not exception. For example, corruption, or the acts committed in the territory, but because of other reasons. Tomorrow I will explain more about that. And with regard to the diplomatic incident between Honduras and Brazil, I think that the issue is not an issue of immunity of state officials. Well, we can see the incident from the perspective of the diplomatic asylum, if it is possible to apply. I'm not sure. Second, it is a matter of diplomatic protection, not asylum, but diplomatic protection, the protection of people who are in the diplomatic locales, the embassy and other diplomatic locales. And I think that is not an issue of immunity of state officials. The fact that the declaration were made in the embassy of Brazil is not an element for conclude that there are specific protection from the immunity of state officials. Thank you.
Thank you very much, Professor Escobar. I think we have written all the questions. And I'd like to offer our sincerest thanks for making us very clear this autonomous institute of international law. There is the immunities of state officials. It was very clear. It was brilliant explanations. And we will be back tomorrow at 8 Brazilian time. Thank you very much for your kind and didactic explanation and deep explanation. And I don't know if you want to make some other remarks for our ending.
From my side, I only would like to thanks your coordination, the moderation of this panel, of this statement speech. Sorry, but I would like also to call the attention of all of our attendants about the risk to make a permanent confusion between immunities before domestic courts and immunities before international courts, because immunities has a different meaning before domestic court and before international courts. And if we missed this both of levels of both of kinds of tribunals, we risk to undermine the great success included, who was the inclusion in the Rome office, the statute of the Rome Statute of Article 27 and the establishment of one international jurisdiction able to act in case when national courts are not able to exercise jurisdiction. But I can understand that it's very difficult to be always in a clear to have always a clear line of for separation of both jurisdiction. But I think that is essential to do it. Thank you very much. And tomorrow we will continue with the work of the ILC.
Perfect. Thank you very much, Professor Escobar. Thank you very much for our kind audience, for the questions, and they also acknowledged the answers, Professor. Well, we will continue tomorrow at 8. Goodbye.
Bye.
Goodbye, Professor Escobar. It was a pleasure to hear you. It was really a pleasure.
Thank you so much. But you know, my English is not so good, and I was always with some doubts about the speech. But I hope that it was interesting.
It was very clear. I didn't have any difficulty. The only one student asked to speak slower. That was the only for me it was very nice, but that was the only observation.
Okay, I will try tomorrow to speak lower.
Perfect. Would you recommend some text that you have published to subsidize this issue, because they are organizing some material to share among them? So if you
I will check if I can send you some documents. Of course, I can send you. Well, I think that I can send you, of course, the reports. The reports, my reports for the ILC, and I will send you I will send to Paula the quotes of the signature of the documents, and I will see if I have some specific because now I'm writing my course at the Hay Academy, and probably I can share with you the PowerPoint in English.
Oh, great!
Because it's broader than for this case, but it could be interesting for students to have some elements.
I'm sure it will be. Thank you very much.
Thank you.
Bye. Goodbye. Goodbye, Professor. Bye, Paula. Thank you.
Bye,
See
Paula.
You tomorrow.
Thank you very much. See you tomorrow.
Thank you very much. See you tomorrow.
Bye.